Thank you, Richard. All right. So thank you, and it's an honor to be here to speak for the Hayek lecture. So thank you to Professor Richard Salzman for inviting me, and delighted to talk to you today about a subject that I hold very near and dear to my heart, both as a long-standing geek, long before I even went into law, and that is one of the reasons why I do intellectual property law as a lawyer and as a professor, is because this is something that I just find utterly fascinating and enjoy thoroughly. I'm going to start by noting kind of an obvious point, something I don't think is controversial, because intellectual property tends to be controversial. So we'll get to that, and I'm going to just lay down some foundations, and then we can have a fun Q&A. But we live actually in a really amazing world today, right? We enjoy high-tech products like our phones and our laptop computers, and enjoy the benefits of a digital economy. We live and benefit from medical cures that were thought to be pure science fiction just 10 years ago. We can treat cancer. We can treat viruses, the scourge of humanity, for 2,000 years. And all of this stuff has just been brought to us in the past several decades. And several decades ago, that period was amazing compared to the 30 or 40 years that preceded that. Now, at each one of these stages, you can look at what are all of these new incredible products and services that people are enjoying the benefits of in our society. And it's very clear that the sale and distribution of these high-tech products and medical miracles are all brought to us by property rights. More specifically, intellectual property rights. Now, this is a bit of a controversial claim for some, because for some economists, intellectual property is very controversial and actually contrary to innovation and contrary to economic growth. In fact, intellectual property rights surprisingly are controversial among Austrian economists and libertarians, the very people who vibrantly defend the free market. Right? So Murray Rothbard and other contemporary economists and libertarians view intellectual property as government monopolies that interfere with rights of liberty and property and trade. And even Friedrich Hayek was at best ambivalent about IP, and Ludwig von Mises as well, another famous Austrian economist, was also very ambivalent about it. Now, my talk today is going to directly take on that ambivalence, or the controversial views, and explain how intellectual property functions in free markets and how it is a key factor in a flourishing innovation economy. Now, the basic point here is the point that Austrian economists like Hayek and von Mises and others already recognize. Property rights as such drive flourishing free markets and thriving economies. This is true for all property rights, regardless of what type of property right you're talking about. Now, I'm not going to be able to cover every issue in intellectual property. I couldn't do that in an hour or an hour and a half, or even the 40 minutes that I've given myself. So I'm just going to cover two basic points. First, legally, I'm going to just describe why intellectual property is in fact a property right, at least as defined in the United States. That it's not a monopoly interest. It's actually a property interest. It shares very important characteristics that other property rights have, and which have been essential to its success in our economy as such. And that's going to be my second point, that intellectual property, when it's been defined as a property right, as it has been in the United States since the very beginnings of our country, that it is part of a thriving innovation economy, which it has been in our country since the very beginning. Now, why this particular focus in my talk today? Why nature of intellectual property rights is property rights, and why am I going to be talking about how and why they function legally and economically? Well, because it's necessary to establish the basic facts, so then we can then have a productive discussion about how is intellectual property functioning and whether it's functioning properly or not today, and all of the controversies that we hear about today with respect to the smartphone wars and other things. We can't get to that type of discussion if what one constantly hears, as I do when I talk to Austrian economists and go to conferences and engage with my fellow libertarians, that intellectual property is just like taxi cab medallions, that these are just special privileges that are conferred by the government. That is not true. but we need to understand that and establish descriptively. So in other words, this talk is descriptive, or in economic terms, it's a positive analysis, right? Because you need to establish the positive foundation before you can then talk and engage in the normative analysis, which is what I want to get to and which we will get to in the Q&A. All right, so let's start. Now, it is revealing and interesting that, that the criticism sometimes of patents as monopolies is their, claim that, oh, this is a grant from the government, this is like a taxi cab medallion, that, when they say that no one else can drive taxi cabs except for you who have this little special medallion given to you by the local government. Now, it's interesting because there's a kernel of truth in that, and that is that intellectual property started several hundred years ago as special grants of privilege from the crown. In fact, we call patents patents. I don't know if you know this, because the crown, when it would disperse monopoly grants, would do so through a legal device known as a letter patent, which was basically an open letter with the crown seal on it that you would show to people to say, I have the right, and only the right, because King George says I do, to run a market here, or to open a mill here, or to build this bridge. And it was called letters patent because it was law French, and in the French, as you know, the adjective follows the noun, unlike in English. And so later in the 18th century, in good Americans, we said, oh, letters patent. So clearly the adjective is letter and the noun is patent, so we'll call them patents. So that's why actually we call them patents, because they do start with these royal privilege grants. But this historical point and this claim, which is true, proves both too much and too little when you're talking about patents today. It proves too much because all rights originate at some point in royal privilege grants conferred by a king or queen at some point. This is true of land rights. Property rights in land started, as we understand them, and with the Norman conquest of England in 1066 with William the Conqueror, who creates the feudal system in England, right? And it's only later when Parliament gets involved and in 1290 enacts a statute that we now call the Statute of Quia Emptoris, which makes property rights in land freely alienable, transferable between people, and no longer a reference point for status in relationship to the crown, that you start to get the shift to what we now understand as property rights, as these exclusive control and right to dispose of something. So it proves too much, because you can, depending on how far back you want to go, all rights, contract rights, land rights, liberty rights, start as some crown saying, I bequeath upon you this privilege, right? It also proves too little. It proves too little because saying this doesn't tell us what then the United States did, what the US did in 1790 when we first started our patent laws and our copyright laws. Those were the very first laws enacted by the very first Congress in 1790. That was different from what then England was doing in the years before it. That the United States had a revolution from England because we disagreed with things like royal prerogative. And we decided to establish the rights to life, liberty, and property as the foundation for our legal system. And this touched upon everything, including patents and copyrights. So, as with rights and land, right, you had this shift from monopoly privilege to property. And this is exactly what the American founding fathers did when they wrote the Constitution in 1787, which authorized Congress to protect the exclusive right of inventors and authors to their respective writings and discoveries. And this is what then Congress did in 1790 when very first Congress, in the very first months that it met for the very first time, they enacted the Patent Act of 1790 and the Copyright Act of 1790. And what the US courts did, which was explicitly contrasted against what England had done and what England continued to do even after the United States was created. Now, what was this? What was this contrast? Well, the United States, unlike in England, which continued to interpret and define patents as grants of privilege from the crown, the United States said, no, we're not going to do that this way. We are going to define patents as property rights. We're going to define them property rights conceptually. We're going to define them legally. We're going to even define them rhetorically with our rhetoric. So, for instance, patents were immediately in the 1790s and the early 19th century were defined as the equivalent of a title deed. The patent defined the boundaries of what your property right was and this new invention that you came up with. And so courts said this is a title deed, just like a title deed in land. And in the same way that a title deed in land defines the scope of your rights of which you can control that parcel of land, a patent document defines the scope of your rights of your ability to have exclusive control over this new invention that you've created. Doctrinally, so legally they went even beyond that though. Doctrinally they did something that was very important which was never done in England. They then took concepts and doctrines from real property, so property rights and land, real estate, as I teach my students in law school, and applied them to patents. Most importantly, they applied the concept that you could transfer your interests in the marketplace. The legal terms are assignment, which is a full outright transfer of a property interest, and license, which is just a small portion. I don't know if you guys know this, but every time, for instance, you throw a party and you invite your friends over, they are licensees under the law. I actually run through examples with my students sometimes about someone comes over, you're on a party, and they spill something and destroy your carpet, and what's the legal issues? You want to sue your friend? Of course you do. You're in law school. But the important point to recognize is that there's actually a legal category called license because you've given them permission to come onto your property for a very limited context, a party. And so you could do the same thing with patents. The courts immediately said you can transfer them, assign them outright in their entirety to someone else, or you can carve them up and say, well, you want to sell or manufacture my invention in Michigan, he wants to do it in Virginia, she wants to do it in New York, I'm going to grant these different rights. I'm going to create different licenses, exclusive licenses in different places so that people can operate in an efficient economic way. They also did something that England never did because we defined patents as property rights, which is they provided constitutional protections to them. So if something is a privilege or a grant, the United States followed the rule that grants from the government don't receive constitutional protection. At least they did for a very long time until the 1960s and 70s. But the basic idea is what the government giveth, the government can take it away. Or in England, what the crown giveth, the crown can take it away. And so if the government gives you a special franchise grant to build a bridge, they can take it away and you have no claim of due process violations or that you've had a taking of your property that requires compensation to be paid to you under the Fifth Amendment, which is the protection for that you have to be paid if the government takes your property. We did the exact opposite with patents and copyrights. The courts immediately said these are property rights, these are title deeds, you can assign and transfer them in the real world, in the marketplace, just like property rights in land and other types of assets. So the rights of due process and the prohibition against taking of your property without payment under the Constitution are also accorded to patent owners. And so legally and doctrinally and even rhetorically, so as a matter of rhetoric, the courts constantly talked about an infringement of a patent right as being the equivalent of a trespass on land. Trespass is when someone comes onto your property in an unauthorized way. You can sue them and receive damages or get an injunction. And they even started calling infringers pirates and invoking and analogizing infringement to piracy from the very early years of our country. Starting in the very first decades, you find the use of property rhetoric like piracy and pirates being used in talking about people who infringe other people's patent rights. Now they did something even more important than this, even more important than just applying and defining and even rhetorically characterizing patents and copyrights as property rights, as opposed to privilege grants from the government. They did something that America was renowned for, which was we embraced the rule of law and we utilized stable political and legal institutions in the patent system. So in England, because patents were conferred by the Crown, it was a discretionary power. It was very expensive for people to access and apply for patents. And if you had issues or problems, you went to the Royal Crown's prerogative court, known as the Privy Council. And it was very much about the government having discretionary authority to do this. And the United States said, we're not England. We don't have a king or a queen. So we first defined in statutes the very precise conditions under which you could get a patent. It had to be new. It had to be something that was useful. We also defined very clearly the terms under which you apply for a patent. And we did something that England and other countries hadn't really done yet, which is we created a special agency, the Patent Office, that was easily accessible to all people, all citizens, under very set rules of procedure for how you would apply for a patent. They created title recordation. So one of the significant ways in which land rights work is that our title deeds are all recorded in a central place, typically the county courthouse. So when you buy land, I don't know if any of you bought a house, but if you buy a house, you have a title search done where they make sure that the person selling it to you has the right to sell it to you, and it also lists all of the issues that may be related to that property, whether there's easements or liens on it and other things of that sort. We did the same thing with our patent office. Every patent is accessible publicly and searchable by anyone in the world. You can access the patent database at the US Patent Office via the internet, uspto.gov or uspto.com, and you can search any patent and find the patent drawings and read the patents, and in fact that's what people do. And as I said, adopting the concepts of assignment and license from property rights and land, they made patents freely assignable in the marketplace. Now, for those of you who know Hernando de Soto and his very important insights about the particular success of economies in the West, you'll recognize that there are some very important similarities here, right? Hernando de Soto's very significant insight about how did property rights succeed in the West and economies succeed in the West, right, is that property rights function only in terms of driving innovation, driving economic growth, only when they are implemented through the rule of law, through easily accessible title recordation, and are freely alienable in the marketplace with those transfers being recorded. And this is an insight recognized by many historians. There's a very famous economic historian, Zarina Khan, who has identified these insights about the early US patent system. And she gave it the phrase, the United States did something that no one else did. We embraced, quote, the democratization of invention, unquote. We made invention accessible to everyone through low fees. We made it set under the rule of law through established procedures and substantive requirements. And we made it a property interest like all other property rights in land and in goods that you could sell or have exclusive control over in any way, shape, or form in the marketplace. So legally, and then ultimately economically, as I'll explain in a moment, the patent system was very much a part of what is called American exceptionalism. Now, American exceptionalism is a term that historians and political theorists use for identifying kind of what the American founders were creating or when they broke from England, right? The United States was created in a revolution predicated for the very first time in human history on a moral principle, the principle of individual rights. And they instantiated this through the idea of rule of law and set legal institutions. And this is exactly what the patent system was part of, just as much as every other part of the American system of government that was affected by American exceptionalism. Now, this is very important. You can see patents are not taxi medallions. Taxi medallion, right, is an exclusive control over that taxi, right? You can't do anything else with it. You can drive a taxi because the only thing that medallion says is whoever doesn't have a medallion can't offer taxi services. And this was the big challenge with Uber over the past several years. And yes, it can be sold, but you can't slice and dice your taxi medallion. You can't say, well, you have half a medallion and I'll take the other half. You have a medallion in New York and I'll have my medallion. That's not possible because it's a special privilege grant to you as an individual. It's not fully alienable. And it's not something that is affected under the rule of law as the way that we treat other property rights. Now, economically, on this foundation, on this legal foundation, economically it's very important to recognize that property rights serve basically two functions, right? First, they secure to laborers the fruits of their labors, right? That's kind of a Lockean moral framing. Economists prefer to talk in terms of incentives. Property rights incentivize people to create property, which makes sense. If you say you control it, you have exclusive control over something, you will then be incentivized to want to create it because your property right will internalize to you all of the benefits of that. So you say to someone, if you go out and find a fallow piece of land and you want to till the soil and plant the crops and grow them, you get them. That's your property. People will then do that. And the resulting effect is, of course, the vast farms in the American Midwest and the cattle ranches out further west and things of that sort. By the way, Locke was very prescient. He actually foresaw the cattle ranches. In the second treatise in chapter 5, he has a comment about how the vast ranges in the American West would be beautiful and valuable if they were populated with thousands of cattle. He said this in 1690, so very prescient. But property rights do more than just incentivize people to create property. They also serve a mechanism for engaging in private ordering in the marketplace, right? So this was Adam Smith's great insight. It's the division of labor. It's specialization, right? This is Hayek's insight about dispersed knowledge and the people having special localized knowledge having the ability to freely enter into exchanges with other people through private ordering arrangements. Private ordering is our economic phrase for basically contractual arrangements. They're free choosing, right? And that prices reflect the information signaling of people's localized knowledge. So property rights serve these two functions, right? They incentivize people to create, and once they create, they have the ability to engage through division of labor. I'm good at creating. I'm a good farmer. You're a good salesperson. I'll farm, and then I'll transfer to you my crops. You go to the market in the city and sell my products, and then we'll split the proceeds. Many people focus on the first aspect when it comes to intellectual property rights. They say it's incentive to create, and that's why we have intellectual property. But they fail to see that the equally second function of intellectual property as a property applies just as much. Now, this insight is important for two reasons. The first reason is because the incentive to create justification for intellectual property doesn't differentiate it from monopoly privileges. If you dangle monopolies in front of people, they'll create just as much as if you dangle property rights in front of people, right? In fact, that's exactly why England, through the Royal Letters Patent, started handing them out. They were trying to incentivize people to come to England from Italy and other places to establish new trades in England in the 15th and 16th centuries. But secondly, focusing just on the incentive to create, right, makes you fail to realize that as a legal matter, again, monopoly grants are not alienable in the marketplace. As I said, they are specific personal grants to people. So the patents in England were not alienable. They were not transferable in the marketplace. If the Crown gave you a patent, that's because the Crown gave it to you. You could not take the Crown's privilege bestowed upon you and transfer it to someone else. What the Crown was giving you was freedom from competition in a particular commercial field, and that was it. This was not the nature of or function of U.S. patent rights as property rights. And in fact, intellectual property as property rights became a robust foundation for extensive and innovative commercial activity in the United States in what economists call both primary and secondary markets. Secondary markets are when assets are sold as assets themselves. So the property rights are transferred as assets themselves as opposed to the property rights in the things. So you sell the patent as opposed to selling the things that the patent represents, like your new smartphone. So the micro and macro evidence has repeatedly borne this out. And I'm going to cover some of this because it's just not known. People aren't aware of it for some reason, but it's out there. So I'm going to cover several different points at the micro level and then cover some of the macro level evidence. All right, the micro level evidence. First, as a preliminary matter, property rights, patents provide the means by which inventors could obtain financing for their inventive work by selling what we call security interests in their patents, right? They could basically use their patents as property rights as collateral. By the way, this is what you do when you get a mortgage in a house. You're using your house as your property right, as collateral for someone loaning you money. And patent owners, inventors did the exact same thing. I mean, there's thousands of examples in US history, but just to give you some prominent examples. So you may have all heard of Samuel Morse. If you haven't, you've probably heard at one point in time in your life Morse code, right? The dots and dashes, the SOS, do 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 do. So I told you I was a geek. Right? Well, actually, Morse code was simply the code that Samuel Morse actually invented to go on what he really cared about and the thing that he really invented, which is what he was really known for, which was the telegraph itself. He invented in the 1830s the electromagnetic telegraph. Samuel Morse was a professor of art at New York University when he invents the electromagnetic telegraph in the 1830s. And like all good professors of his day, he was dirt poor. And he was engaging in extensive experimentation on the cutting edge issues and electromagnetism and electricity. And so he sold interests in his future patent right to people to assist him, specifically Leonard Gale, who was a professor of chemistry, a fellow colleague of his at NYU, and Alfred Vail, a former student of his who had a knack for mechanics. He paid them by giving them interests in his future patent that he would eventually apply for and received in 1842 on his patent. He also later sold interest in his patent to Francis Smith, who was a political operator, but also who was a business person who had good acumen, and Amos Kendall, who actually ended up transferring the entire control of his business empire over to Amos Kendall, who set up the American Magnetic Telegraph Company for him because he was a painter. He didn't want to. In fact, he often wrote in letters, "I hate business. I'm awful at it. It just is not something I'm good at. In fact, I love painting. I just got caught up in this telegraph thing, and I got caught up in this invention bug. I don't want to run a business." And being able to sell these interests in his patent right, not only was he able to fund his inventive activities, he was also able to transfer his invention to people who were better at it than him. So another example is the sewing machine. Sewing machine, which comes to final fruition in about 1850, was the smartphone of the 19th century. It had been something that people have been trying to invent for about 100 years, and a lot of different people got patents on different aspects of what eventually becomes the final sewing machine. So it actually ends up in a massive patent litigation in the 1850s that they called the sewing machine war. So even calling it the smartphone war today is not even original. They called it the sewing machine war, and it was all these people, patent owners, suing each other. Whatnot. But one of the primary patent owners was Elias Howe, who again was this destitute, poor individual who invents the lock stitch, which is a primary key mechanism used in all sewing machine devices. And when he discovered Isaac Singer using the lock stitch without paying him a license, he went to Isaac Singer and said, "You're using my patented technology. Please pay me a license." Isaac Singer was known for being a very irascible fellow, huge temper, so he threatened to throw Elias Howe down the stairs and step on his neck and kill him. This was the day, this is the day before, email or even good letter. If you wanted to ask someone for a license, you had to go to them. Right now, you send them a letter and you get a strongly worded email in response. Right now, but there you had to go and have Isaac Singer threaten to kill you. So Elias Howe had no money, zero money. He was totally poor. He couldn't even afford to file a lawsuit. So he sold a security interest, a 50% interest, to George Bliss in his patent, who provided him money so that he could bring at least the lawsuit, afford to pay a lawyer to file a lawsuit against Singer for infringing his patent. But I don't need to go to Samuel Morse or even Elias Howe, because we are very much aware of this today because of the show Shark Tank. I don't know if any of you have seen Shark Tank, one of our great reality shows today, when people go and sit in front of 3 or 4 venture capitalists and pitch an idea to them to try to get funding. Well, whenever there's finally an idea that they're interested in, what's the very first question that they ask that person? They say, "Do you have a patent?" And sometimes the person says, "No." And they're like, "Are you insane? You just went on national television and gave away your entire idea. There's no reason for us to invest in you." Venture capitalists consistently report and rely upon patents as a basis for making investment decisions in startups. Now, this has actually now been proven as an economic matter. It's a very significant, famous study recently done by Joan Fair-Mensah, Deepak Hegde, and Alexander Lindquist called "What is a Patent Worth?" You can download it off the internet, but they got access to a massive data set of patents at the Patent Office and were able to finally prove for the very first time that patents are causally linked to more than doubling your chances as a startup in getting venture capital funding. In fact, I was at a conference where an economist very well-known, renowned economist, referred to this study as the holy grail of what economists have been trying to prove about the patent system for decades. They're not a correlation, a causal link between having a patent and the ability to get venture capital financing. More than doubling your chances. Then they actually they took it even further and they said, well, since you got venture capital financing, you were able to hire more employees, you were able to develop your product faster. So they were actually able to show a causal link between a startup making it through what is called in the venture capital community the valley of death, which is when you just start your startup and you've got money, but you're burning through more money than you're actually bringing in because you're just getting off the ground. They're actually able to show that having a patent is causally linked to going across the valley of death and actually becoming a successful small to medium enterprise in the marketplace, moving out of startup phase and having a successful product in the marketplace. So that's just some examples at the micro level of patents serving a key purpose, as all property rights do, and serving as a basis for investments, serving as collateral, security interest, because that's what the venture capitalists do. I'll give you $500,000, or I'll give you $500 million, you give me your patent. So that if you go belly up as a startup, which most startups do, I get your patent and I can sell that and at least make some of my money back. Because I'm a venture capitalist, I don't want to go into business, I just want to recoup for some of my losses. Second, as property rights. A second micro point to remember, as property rights, patents provide the foundation for the division of labor in the efficient commercial exploitation of products and services. Again, Samuel Morse. Samuel Morse, remember I said he was a painter, an art professor. So he wasn't a business person. He didn't know anything how to do business or run a business, right? So this is why he sold interest to Francis Smith and Amos Kendall. They were business persons, very, very effective, good business persons. And they took his patent into technology and his property rights and developed it into a business. And that's what you want. You want inventors inventing and business persons engaging in the marketplace in the ways that they can do it, given their knowledge. And they weren't the only ones. Charles Goodyear. You may have heard of Goodyear Tire and Rubber Company. Charles Goodyear, the inventor of the process that makes rubber a workable commodity that we use, and it's in everything, your shoes, tires, devices, it's even in your phones, right? By the way, he had nothing to do with Goodyear Tire and Rubber Company. It was named after him 40 years after he died, precipitated a trademark battle between him and his children. Goodyear was just a crazy inventor. He was crazy about rubber. It's in fact the only thing he invented was this process. He figured out how to do it in his wife's kitchen, ruined a bunch of her pots in the stove in the process of doing it. But he wore chunks of rubber in his clothing, and he made things out of rubber. He loved rubber so much he wrote a treatise about how awesome rubber is, which has pages and pages after pages of just him listing all the things you can make rubber out of. You can make boats out of it and life preservers out of it and all sorts of stuff. And then just to prove his point, he had his book bound in rubber. So the guy was your classic example of a nutcake inventor, right? He never manufactured a single piece of rubber in his entire life, which was a good thing because he was crazy, right? What he did was he licensed his patent to other people. He was the exact person, remember earlier my example of you make my patented invention in Michigan, and the other person will make it in New York, and the other person will make it in Virginia. That's exactly what Goodyear did. In fact, Goodyear was one of the four leaders, innovators in this process of slicing and dicing up very finely. Like, you can make rubber umbrellas only in Boston, and you can make rubber umbrellas only in Detroit, Michigan, and you can only make 100, and you can make 50, and you can only sell them. I mean, he really engaged in this to make money from his invention, from his property rights. Nikola Tesla, if you guys know Tesla fame, Tesla cars, named after him, right? The man, another crazy inventor. invented many, many, many things. You know how economists have referred to his business method or his business model? It was promote, patent, and sell. And sell wasn't sell the patented products. Sell was sell the patent. Because he didn't want to manufacture. He was an inventor. And in fact, Tesla invents alternating current technologies and electrical distribution systems. He was able to do that because he worked with Edison originally, who invented direct current in the original invention of the first practical light bulb and electrical distribution systems. And Tesla sells his patents on alternating current distribution systems to Westinghouse. Edison eventually sells his patents on direct current electrical distribution systems to General Electric. And General Electric and Westinghouse get down to the business of doing what we expect corporations to do, which is manufacturing products and fighting it out in the marketplace and also fighting it out in the courts. In fact, it was called the Great Electricity War. Just to show you, war is nothing new when it comes to talking about patents. And Thomas Edison. Thomas Edison is another example of an inventor who makes his life by patents, embracing the division of labor, embracing the specialization, the very notion of what makes an economy, a successful economy, work. Thomas Edison got almost 1,200 patents in his lifetime. He invents the very idea of an invention factory. That's what he created in Menlo Park in New Jersey, an invention factory where he just hired people to help him invent. And he was really good at it. And so he licensed his patents to people to manufacture, to Western Union and other types of places and other types of businesses. Later in his life, after he invents the motion picture, after he invents the first practical incandescent light bulb, after he invents electrical distribution systems, after he actually invents follow-on technology to the telephone, which actually ends up being central to the success of the telephone upon Alexander Graham Bell, he says, oh, I'm really cool. I can go into business and I can do these things myself. And he was awful at it. He was awful at it. He invents the record player, which he called the phonograph. Actually, you know what record players come to be called? Not phonograph. They come to be known as the Victrolas. You may have heard that term. Victrolas, they were a competitor with the phonograph. The reason why the Victrolas succeeded was because the phonograph was awful as this commercial product. Edison was like, I'm an expert on music. No one can put music on this that I don't approve. Victrolas like, anyone can play any music they want. We don't care. And Edison was awful as a businessman. His business enterprises failed. Henry Ford, who was a personal friend of Edison, loaned him. We don't know actually how much he loaned him, but current estimates are well more than $1 million. And this is in the turn of the 20th century, so that's a serious chunk of change. And he lost most of that. Of those personal loans. He famously said of Thomas Edison, he said, Edison is the world's greatest inventor and the world's worst businessman. Right? We want people to embrace division of labor. We want professors to be teachers. I'm not a good business person. I shouldn't be running a business. I should teach. And other people should run businesses. And I should benefit from their products that they make, and hopefully I can teach their children and they can benefit from, and their children can benefit from my skill set. And this is what makes an efficient economy successful and thrive and flourish. I could go on and on and on, but the point is that there's also a very important and significant economic study by the economists Ken Sokoloff, Naomi Lamoureux, and Zarina Khan, who looked at the 400 great inventors in the 19th century. Great inventors were inventors who had the most significant patents on most disruptive technologies. So this is like Charles Goodyear and Samuel Morse and Thomas Edison and other people like Samuel Colt, the Colt repeating firearm, and Eli Whitney, the cotton gin, and so on and so on. And they found that a significant majority of them actually licensed their inventions. They did not actually set up manufacturing facilities and license. They embraced property rights and the very economic function of why you protect something as a property right. As opposed to England, since it was a personal grant to you in England, you had to manufacture. Watt, who received the very famous patent in England on the steam engine, had to manufacture steam engines. He couldn't transfer it to someone else. But in the United States, Goodyear could say, I don't want to make dental implants. You go make dental implants, one of his very many licenses, who got in a huge patent war and got in lots of litigation. In fact, there was a vibrant licensing and secondary market. And I'm usually not a fan of PowerPoint, but I will use this just to show you. So I found these in doing some of my own historical research. These are classified ads. By the way, kids today have no idea what that is. This is the Craigslist of the 19th century. So if you wanted something, you were looking to sell something, you would go to the back of a magazine or newspaper, and there would be all these little squares listing people selling services and products. Well, in the 19th century copies of Scientific American, which was started by a patent attorney, there was all of these want ads and classified ads for literally the sale of patent licenses and of patents themselves. In fact, this is one of my most favorites. These are from, I think, an 1854 issue of Scientific American. I love this. A patent on a farm gate to sell or exchange for a number 1 3-horsepower portable steam engine. There you go, right? The value of trade in one thing. I'll give you my patent if you give me a steam engine, right? But more importantly, right, agents for the sale of patents or sale of a variety of valuable rights, because they were patent owners also hired patent agents who were business persons who would sell their licensing rights. And so patent rights sold on commission and valuable inventions introduced by the most experienced patent salesmen in the Union. So these people will go around the country selling your patent licenses and patent assignments to other people. And there's just some other examples, right? For sale, the patent of a self-unloading and adjusting hay elevator, patented I can't read that, but 1854. Patent rights for sale, again, patent rights for sale. I mean, the Scientific American is littered with these. There's a huge, vibrant market in both patent licensing in the 19th century and in the sale of patents themselves, which is the secondary market in the asset. So, third, as property rights, patents provide a foundation of the set of exclusive rights, the control rights, right? A right is the right to exclusively control how something's used. So you can say to someone, stay off, no trespassing, because I want to, or I want to build a house, or I want to build a factory, or I want to build a skyscraper, or I want to keep it completely, wild and uninhabited because I want deer and lions to come here. So you can do whatever you want with it. That's exactly the point, right? Is that property, through localized knowledge, private ordering mechanisms, provides for people to engage in innovative commercial development and methods for exploiting new products and assets. Again, the sewing machine. I mentioned how the sewing machine ended up in a massive patent war, a sewing machine war of the 1850s. It was solved by the patent owners who got together and said, we really should stop suing each other. What we should do, since we all have several patents, or we all have the property rights, we should license each other. It's called cross-licensing in law. I license you, you license me. We cross back and forth our license. And doing so, then, we can get down to the business of selling it. But hey, let's be even more efficient about this. Let's pool all of our patents together and put it into a trust and have that trust function through one individual, and that person will grant licenses to all sorts of people, and we'll benefit from those licenses because the royalties will be split between us as the various percentage owners of the rights in the final product in the sewing machine in the marketplace. This was called the sewing machine combination. It's also known as a patent pool, where for patents owned by hundreds of or even tens or thousands of different people are brought together and put under a single commercial entity, which provides for efficient reduction of transaction costs and the efficient licensing and manufacturing of the products in the marketplace, because you're reducing transaction costs and the number of people you need to transact with. And patent pools became the foundational basis by which most technology is actually brought to market. Do you guys use MPEGs? You're benefiting from a patent pool. Anyone here have LASIK surgery? You benefited from a patent pool. Anyone here use a JPEG? You benefited from a patent pool. Anyone here? I mean, there are thousands of patent pools, and no one knows about them because they operate in the background. They operate underneath, where business persons are interacting with each other, and they're looking to negotiate deals to sell products in the marketplace. Remember I told you Samuel Morse transferred his interest and control over his patent on the telegraph to Amos Kendall to set up the business? You know what business Amos Kendall created? A radical new type of business. Something that we well know now because we go to McDonald's and Wendy's and all others, called the franchise business model, where I'm not going to actually control everything. I'm going to license to you to use my name and use my property rights under certain conditions, but you take all the risk in building the manufacturing capabilities, or in this context, setting up the telegraph processes and whatnot. It's an incredible commercial innovation that was developed in the 19th century in the United States. And it was developed by patent owners to reduce the risks inherent in commercializing their interest in the marketplace. By the way, Alexander Graham Bell did the exact same thing with the telephone. After he originally first tried to sell his patent on the telephone, he invents the telephone to Western Union, and Western Union says, oh, no, we don't want it, it won't work, it's crazy, what a crazy idea. People are sending telegrams, it works perfect, right? People go to the telegram office, send a telegram, quick, right? You know, Johnny hurt, stop. Send $5, quick, stop, right? We don't need a telephone. Well, Alexander Graham Bell really wanted to exploit this technology. Well, he wasn't a business person, so he turned to a bunch of lawyers and business persons, and they developed a franchise business model, where they licensed the rights in the patent to other people and other companies to develop telephone systems throughout the entire country. And that's how we ended up with the various bifurcated different telephone companies initially in the country. I could go on and on and on, but the point I think is well made. Now, similar as the micro level, there's tons of macro level evidence too that patents as property rights, as you define them properly as property rights, alienable, right? Right to exclude, defined through the rule of law and stable political and legal institutions, right, contribute to economic success and flourishing economies. One prominent example is there are numerous studies, that show that developing countries, if they adopt property right-based IP systems for patents and copyrights and IP, that what they immediately see is a positive inflow of foreign capital investment, which is fundamental to a developing country. That's what exactly they need, right? They don't have the resources in the country itself. They need foreign investment to bring more money. They need a trade deficit, right? They need more money coming in than going out so they can build their infrastructure and build the resources that they need. There are also a tremendous number of event studies that have shown that patents are fundamental to the growth of certain types of industries that share certain characteristics. So for instance, in the biopharmaceutical industry, the biotech revolution of the past 30 or 40 years, genetic engineering, modification, design-based methods from the protein up for designing the molecules that treat cancers and various illnesses, this all gets started from a single US Supreme Court decision in 1980 called Diamond v. Chakrabarty in 1980, which involved a guy invented a bacteria that ate oil. He genetically modified a bacteria to eat oil. And the patent office said, you can't patent that. That's a bacteria, that's living, that's an organism. And it goes all the way to the Supreme Court, and the Supreme Court says, that is something that's a technology that has been invented by man. You know, it's genetically modified. That is classic technology. And what's really important is the United States, so the United States said, you can patent this. Other countries didn't. Other countries said, nope, no patenting life, no patenting these basic products of the world. And as a result, you have in a classic, what economists call event study, massive development of R&D and venture capital funding flowed into the United States, into startups developing all of the biotech innovations that we now take for granted and are fundamental to our medical treatment today. And this is widely recognized. And the rest of the world eventually follows us because the biotech revolution starts in the United States and starts because of this Supreme Court decision in 1980. There was a similar Supreme Court decision in 1981, the year later, called Diamond v. Deere, D-I-E-H-R. And that relates to the patentability of software, and that correlates with the personal computer revolution and other things. It's a little bit more controversial, but as a general matter, the United States provided both copyright and patent protection to high-tech innovation long before other countries did. And many people have identified this correlation and have said this is a very significant correlation, and we haven't had counter-explanations about what could explain that correlation away. In fact, correlations are exactly what you find very often in a lot of studies, consistent, repeated studies. So very famously, there's a very famous article a new article that just came out last year by a Stanford political economist named Steve Haber called Patents and the Wealth of Nations. For those of you who have political economy backgrounds or economic backgrounds, you'll notice the symmetry with Wealth of Nations, Adam Smith, and where he actually surveys the historical and econometric evidence on patents. And one of his points that he identifies in his essay is this. Here's the site. But is that there is no advanced economy in the world that does not provide strong patent protections. And that's represented by this. Now that's a correlation. That doesn't prove causation. You can't say, ergo patents cause strong economies. But what that does say is that's a very strong correlation. And so what that does say is then that needs explaining, right? If you want to say patents stop innovation, that's great. But then you need to explain what's going on here. And you need to figure it out. There's no poor country that doesn't provide patent protections that has a strong economy. There's no strong economy that doesn't provide patent protections. Now, I have often heard libertarians and economists say, when I've talked about this, say, that's just correlation, as I just mentioned. That's not causation. You can't say that. But that gets the burden wrong, right? You start with correlations. That's exactly what you start with when you start investigating the world. You start collecting data, and you start finding correlation and correlation and correlation, and you start controlling for trying to, within particular studies, controlling for correlations and whatnot. But the important point here is that what you have is a very strong correlation. And by the way, this isn't just one. This is him summarizing other studies as well. He covers numerous studies and shows you get similar correlations again and again and again, right? And you have to be careful about saying, well, we have to have causation. You can't defend IP unless you have direct causation that IP leads to innovation, right? Because the fact of the matter is that right now we don't have a direct economic study that tells you protection of rights to life, liberty, and property and contract are causally linked to flourishing economies and robust innovation. There isn't any. It's just a correlation. By the way, equally on the flip side, it's just a correlation that every communist regime has led to mass murder, destruction, and death, right? Whether you're talking about USSR or Cambodia or now Venezuela, if you want a shock, go. If you haven't been following what's happening in Venezuela, it's really scary. That was an advanced economy just 10 years ago. And they are now digging in the dirt. It is a destruction of an entire economy. Now, of course, and by the way, this is what defenders of statism often say, right? Well, that's just an accident because of all these other features, right? Well, we shouldn't forget that Austrians, right? Austrians and libertarians often rely upon strong historical evidence and correlations of the type that I've identified to defend the free market and the virtues of limited government, right? Mises did not say, I have an econometric study that proves that economic calculation is impossible in state economies, right? It's not what he said. And his economic calculation thesis was right? Hayek doesn't present a regression analysis in the Constitution of Liberty, proving without a doubt, holding constant for all potential confounding variables, that protection of property causes economic success, innovation, and freedom, right? So, and in fact, that's very important, lest we forget. There is not a single study, there is not a single econometric study that shows as a causal matter that protection of property rights in land lead to economic growth and flourishing economies and free societies. What we have is a bunch of studies that show property is one of many factors, right? And this was Hernando de Soto's great insight, right? You can't just say, we've created property, ergo success. It's one of many variables. You need rule of law, you need title recordation, you need efficient mechanisms in the marketplace, you need that provide for division of labor and specialization, and so on and so on. And of course, as property, intellectual property, when it's defined properly, isn't part of that variable. And that's what these studies repeatedly and consistently show on the macro level. So in conclusion, I just want to point out, I went on for a little too long because I got too caught up in my stories. I'm sorry. I don't know how many of you know Ronald Coase's very famous investigation of lighthouses. He wrote a very famous article called The Lighthouse in Economics, published in the Journal of Law and Economics in 1974. And it's a very short little essay, and it's a wonderful essay. Because what Ronald Coase does in this essay is he says, lighthouses are constantly offered by economists as an example of a public good and something that you have to have, therefore, state funding and state support for, because no one will provide for it, because you have positive externalities that you can't internalize because the light shines everywhere. It's just so in all the case books and all the textbooks, lighthouses, and this is why we have publicly owned lighthouses, and they would point to a bunch of examples, right? He said, so that's the theory. He says, that's an interesting theory. So I decided to go look at the history of lighthouses, Coase did. And Coase said, so I went and looked at the history of lighthouses. And what did I find? I found that actually lighthouses were created by private organizations and private individuals in history because, yes, they recognized the problem of the public good, positive externality aspect of a lighthouse. And so they figured out ways to control for that and to internalize those positive externalities to efficiently develop them, such as having associations developed around harbors. And so charging harbor fees to private individuals who wanted to use those harbors that would then go to the supporting the maintenance of the lighthouse. In other words, what you saw was the classic development based upon localized knowledge of a private ordering mechanism that you would expect to arise in a free market when faced with a problem of how to provide a service effectively in that market. Excuse me. Well, the exact same thing I find to be the case with IP. Everyone says IP is monopolies, it's taxi medallions, it holds up innovation. Everyone has an anecdote or two to back it up, right? Or they back it up with the economic theory that, well, property is the solution to scarcity. Ideas are not scarce, ergo patents and copyrights are not property, a pure theoretical deduction. But when you actually go and look at how intellectual property functions in the marketplace and how it actually has functioned historically, and how actually, when you go and actually look at the macroeconomic studies which look at the actual facts, what you find is actually it is, when it's defined properly as a property right, because it could be misdefined, it could be if defined as a monopoly privilege as it was in England, then it functions as every other type of property right. So in sum, a free society with a free market, right, is a complex system with many independent variables, political and economic. And when IP is defined as a property right in the law, the historical and economic evidence overwhelmingly shows that it is a key variable in a flourishing innovation economy. Now, advocates for the free market should no more condemn intellectual property as such, given a few anecdotes of abuse or a few misdefinitions of IP in the law, right, than we would to condemn capitalism given the advent, for instance, of crony capitalism, right, of cronyism, and of other types of destruction of regular property rights in the law or in the culture, right? Intellectual property is not a step down the road to serfdom. It has been and is a key legal, political, and economic factor in a free society and a flourishing innovation economy. So, thank you.